with our seminar. We have Mariana Llanos from the GIGA Institute in Hamburg with us. She arrived in Brazil on Sunday, spent some time and did work in Rio, and now gives a presentation on why judges leave the bench, which is one of her, like the judicial politics is one of her main topics of research. She did her, just briefly wrapping up, she did her undergraduate studies in Buenos Aires, then did her PhD in Oxford, and then made her academic career basically in Germany, starting in Augsburg. And since 2001, she joined the GIGA Institute, one of the main research institutes on comparative politics in Germany, I would say. She has a broad range of interests, so she lectured on gender and politics, on political representation. But two main topics of her recent work are on presidents in Latin America, how presidents fail, or presidential failures was one of her last publications, or she co-edited a book on how presidents fail. But she published extensively on Latin American presidentialism with Brazilian co-authors, Magna Inácio. She published on constitutional reforms, and now recently more and more on judicial independence, on how judicial institutions are designed. Interestingly enough, also on informal aspects, informal interference in the judiciary. And also interesting is her comparative work, including Latin American countries and African countries. So this is more or less the field of research she works now on, and she will do her presentation basically on a comparative on this comparative topic, comparing 3 African countries and 3 Latin American countries, answering the question of why judges leave the bench. Thanks a lot.
Thank you so much for this invitation. I'm very pleased to be today in São Paulo, and thank you the University of São Paulo for letting me be in Brazil again. I'm very fan of this country. I love Brazil, and I don't come very often to São Paulo, and it's great to be here. So I want to thank also Bruno, because he's been handling with all the details of my presence here, taking me from the hotel to here, and reading and writing emails and so. So thank you very much. And Rogelio, I know Rogelio for a long time, and I know he will be interested in this topic. I hope you also will be interested in this topic of the judges, because I do political institutions for a long time, but I don't consider myself a specialist in judicial politics. But this is my problem, because after 4 or 5 years of doing this, I should be a specialist already. But I could say I'm a specialist in comparative political institutions, and I like very much this how the institutions relate to each other. So the president and Congress and the judiciary and so on. So I'm from Argentina, so I'm able to speak Spanish if you don't like my English. So you tell me, I can change anytime. I can't speak, I understand perfectly Portuguese, but I will speak, hopefully, if I try. I will speak Portuñol probably, but if you want to ask questions, also you can do in Portuguese. I do understand, and it's no problem. Okay, first, how would I introduce this topic? It has so many kind of things to clarify. The first thing maybe is, what is this idea of comparing Africa and Latin America. Where does it come from? Well, I have to tell something about GIGA. GIGA is the institution where I work. And in GIGA, we are organized in 4 different regions. So we are actually 4 institutes working together. And each institute has a regional expertise. I work in the Institute of Latin America, but there are people working on the Institute of African Studies, of Asian Studies, and of Middle East Studies. And then we have some research programs in which all the 4 institutes, or the people from the 4 institutes with the same interest meet and grasp the same topics. And this is how this project was born, with the idea of exploring what's going on with the new constitutional courts that were being created in Africa. And as we have much more advanced research on courts in Latin America, we could apply the expertise that we have on the Latin American cases in understanding what was going on with the new constitutional courts in Africa as well. And it was very interesting because in this process in which we thought that Latin America would be teaching something to Africa, it happened that I, as a Latin American, learned a lot of our region by reading the literature on Africa as well. And this is the reason why I began to do research also on informal ways of interfering with the judiciary in our region. Okay, this is a background, and a little bit on the motivation as well, because why it would be interesting to study how judges leave the courts. Is this an interesting topic or not? And if it was 1 year ago, I would say this is not interesting for Brazil at all, because you don't have the kind of things that happen all the time in other countries of Latin America, or not so not such big problems as we have in other countries. I come from Argentina, and how the judges leave the bench has been an issue all over the Argentine history, at least since the 1940s, because the political branches have interfered a lot with the time that the judges are sitting there and doing their work there. And if you open the newspapers, the Argentine newspaper today, is anyone here from Argentina? You. So you read today something on judge? Fight. The fight is sí. And there is harassment on a judge from the part of the government to make him resign. I can tell you a little bit more on fight if you are interested later. He's the oldest judge of all. He's there from the 80s, but he's very renowned judge. But the interest is this harassment to make him resign, to get this position free. And there is also, since the last 2 or 3 weeks, no, maybe more, this threaten to enlarge the number of members of the Supreme Court, because the government doesn't have the special majorities to appoint a judge, but has the majorities to change the law with the number of judges of the court. So it's kind of playing around to change the composition of the court. So this is something you don't see very much in Brazil, but we are not going to talk on Brazil now, but we can talk later on in the question time, because yesterday there was something in the Senate with the appointment of a new judge, and there was a change of the rules also a couple of weeks ago, so there's something going on, which is quite new for Brazil, but it's totally old story for other countries of Latin America, and Argentina, and Paraguay, which is another country of my research, are very much affected. So this is the motivation. Why do judges leave the bench? Under what conditions do they leave? And the importance of this is because judicial stability, the stability of the judges, is normally regarded as very important for judicial independence. And judicial independence is also regarded very important for the rule of law in a country. So when the political branches mix too much with the judiciary, it's something threatened. And the first thing that's threatened is judicial independence. So this is something on which there is agreement, more or less, in the academic world. And this is a reason why all constitutions have provisions for the time to secure that judges stay there for a long time. So there are provisions in all constitutions for the protection of the tenure of a judge. But in the real world, we have differences in what the Constitution says and what happens in the practical, in the real world. And if you go to the established democracy, maybe a judge resigns because of personal reasons. He has other interests or wants to pursue another career or whatever. But if you go to less established democracies, the reasons why the judges leave are sometimes not personal reasons or not their own decisions, but they are forced decisions. So they have to leave the bench because they are forced to leave. And according to the literature, there seems to be a divide between developing countries and established democracies. This divide refers to the term length, so how long the judge stays in comparison to what the Constitution is saying, and also to the reasons why a judge is leaving. And in established democracy, you would say, okay, he goes because of personal reasons or his own decision. In another context, not so established, we could argue there are much more judges that leave because they are forced to leave the bench. And many of the Argentine examples are kind of this second type of departures. So what are the research questions that we are posing in this research? The first question is the how. We want to know how the judges leave the courts, and to what extent they do this in a duly way or in an unduly way. So to what extent they go because they have to go because the term is ending, and to what extent they go because they are forced to leave. This is the how. And then we want to explain why they go. And this is very interesting because the judicial politics literature is quite advanced and kind of explanations. And I have summarized these explanations in 4 types of factors. We could say the political factors that have to do with who and the power that they have, those who are in the government. Then the institutional factors, which are the rules of the game. Then we have personal factors. Who are these judges? Do they contribute themselves with their personal characteristics to be dismissed from the courts or not? And then we have the socioeconomic or structural factors, which have to do in which kind of situations or countries these judges are acting. So let's explain a little bit more in detail the theory and the factors, how they could affect the departure of a judge. Well, the first thing are, of course, the rules for judicial tenure. I'm going too fast, you tell me. Are you fine? Okay. If we go to the institutional factors, the first thing we look at are the rules for judicial tenure. And there are three general kind of rules. Some constitutions rule that judges stay there for their whole life. So once they're appointed, they only leave when they die. A second rule established that age limits. This is the Brazilian case, I think. So you had until a few weeks, 70 years to be there, and now you have 75. And then you have to go. And then you have term limits. There are many constitutional or Supreme Courts that establish a term of 5, 6, 8, 9 years, depending on the country. And they renew the judges more frequently than other courts. If we think in the effect of these rules, the theory normally says the longer the judge is staying, it's better for the independence of the judiciary, because the political branches are not mixed in too much with what's going on there. We are going to see what are the practical implications when we study what happens in empirical terms in the real world. Then we have the rules that define the power of the courts. If you have very powerful courts, or if you have heard probably about this phenomenon of judicialization of politics, if you have a lot of judicialization of politics, or courts that are deciding a lot on important cases, then the interest of the political power is higher to get involved in the composition of the courts. And they probably would like some judges to leave earlier than others because of this reason. So if you have courts with the power of constitutional review, which are the courts I work on, all have this power, then you will see that the political branches are looking at what's going there all the time. Then we have, of course, the institutional powers of the president. This is very established in the theory also, that presidents with a lot of power, they have more interest and also more instruments to mix with the courts as well. And then we have, according to the theory, the importance of constitutional reforms. In developing democracies, more and constitutions are reformed all the time. In Brazil happens, it's very often, but it's not only Brazil. In many, they define the rules of the game many times. And the power and the independence of the judiciaries has been rewritten several times in many constitutions. And some authors have already detected that these are crucial moments for the independence of the judiciary as well, because when the rules of the game are changed, maybe new judges are appointed, or new or the courts are enlarged. So it's a kind of window of opportunity for political intervention as well. So we have to look at closely what happens when constitutions are reformed, because this could have an impact on the stability of the judges as well. Okay, these are the most relevant institutional factors as mentioned in the literature. Then we have political factors. There is a very famous theory in the judicial political literature, which is called the fragmentation theory or the insurance theory. I don't know if you have heard about that before, which means that when the political power is fragmented, the independence of the court is higher, because to get involved in the business of the court, you need these strong majorities. Otherwise, you can't change the rules. And the fragmentation theory has found evidence to show that this is so. So when you have fragmented legislators, the independence of the courts is higher. And also, when you have turnover, when you have situations in which the party in power knows that's going to lose power in the coming elections, it has interest in maintaining an independent court, because it's a kind of insurance for those in power that the rules of the game are going to be respected. This is Tom Ginsburg's theory he wrote on the Asian cases, and it's very much used as well. So there are political factors, and you can, if I think in Argentina, and there are many authors working on Argentina, they have found strong evidence showing that when the Argentine president is powerful in Congress, has a majority in Congress, will try to go do something beyond the normal function of the court, will try to mix with the composition of the court somehow. Okay, then we have the individual factors. This is interesting because we detected some that the profile is English. Sometimes I don't know if it's German or English. It's English. We detected that the especially in developing democracies, the type of the individual could be important, because the insurance theory has been very much criticized for that parts of the world that are not so consolidated as democracies, because you have so much instability in the political sphere that it's very difficult to predict what's going to be the outcome of the political regime as a whole. So individuals play a bigger role than institutions sometimes. So we thought that we should include some individual factors as well to see if they play a role themselves in if the judge is going to stay in power in the court or not for a longer time. So we need to analyze if judges are politically oriented, if they have a real political affiliation or not. Some judges in some parts of the world they do have, although they shouldn't, but they do have a political affiliation or identity. And we should analyze also the professionalization. If they are very professional, they shouldn't be more respected. So all the political power, we could say, wouldn't dare to go so far with more professional judges. And then we have to analyze also, we say, the position of the judge in the court. In some courts, the president of the court has a more relevant role than other. So there is an internal hierarchy in the court, which is not in all the cases, but in some cases, in the African cases, for instance, is the president of the court has an important role in organizing the agenda of the court, for instance. In other cases, they have more visibility, so they become more political figures than other normal judges, or more visible figures. So when a change in the political sphere occurs, we could argue that the president of the court is one of the first ones that's going to jump out. And then we have, as I told you, the socioeconomic factors, because all the theory as it has been developed until now, it's not such a developed theory. We actually don't have many studies on this. We have a lot of studies in judicial politics measuring empirically judicial independence. And judicial independence is, and judicial tenures are part of judicial independence. But most of these studies, what they do is they check with experts. So they interview experts, and the expert opinion is what defines more or less the level of judicial independence or all the knowledge we have on judicial tenures is due to these interviews. So we don't have many studies dealing specifically with judges, because it's very difficult to do. They are not so known people as politicians, and to do research is very much time consuming. You have to go into archives, or you have to do a lot of interviews, you have to do field work. So there are not many, but there are some. In Latin America, I could mention, I don't know if you know Aníbal Pérez Liñán. You heard about him because of probably his studies on presidentialism, impeachment, and so. But he's also done some work on the stability of judges in Latin America from a historical perspective. And this is one of the few studies that we have in which we compare judicial tenures. But there are not many like that. So all of these things are assumptions that we do without really testing them, because we don't have so much data. And this is why I'm very proud of the paper I'm presenting now, because it was really a lot of empirical work and to collect information and then to test this. How much time do I have?
Plenty of time.
But if you get bored, you tell me, so I can do it shorter. So what did we do? As I told you, this is not an easy comparison. We decided that we wanted to study judicial tenures, and since it's very difficult to get judicial tenures in developing democracies, so not in established democracies, and since it's very difficult to reconstruct and to get data on the CVs and the lives and the stability and whatever of all these judges, we had to work with a few number of cases. We couldn't go from the beginning with a large number of cases, so we had to organize a small n design. You know what this is, small n, so a small number of cases. But then we had the possibility to cooperate with the people doing the same research on Africa. So we designed a project in which the same questions and the same kind of interest were being asked in Africa and Latin America. And we did this with the colleagues at the Africa Institute. And it was very interesting to do this cross-regional research design, because although we had only a small number of cases, the questions that we posed for our research were large questions, were big questions, because we have to embrace very different cases within the research. So this is people who do this kind of research, they say that the cross-regional small and research designs have this, give you this possibility to combine this deep field work or very deep research on a very small number of cases, but then to pose large questions and to make large propositions to embrace very different cases. And then we decided to take 3 countries in Latin America and 3 countries in Africa that had different levels of behavior in the democratic variables. So they are all democracies, they're all being part of the third wave of democratization, but they have different standards of the quality of the democratic regime. So you know, Chile is the best case for the sample. Argentina is always like so, and Paraguay would be the bad case. But in our case, it's not always Paraguay the worst case. Sometimes it's Argentina the worst case. But when we look for the indicators to choose the cases, it was more or less the distribution. And in Africa, it was exactly the same. So we took only Francophone countries in Africa. They had created new constitutional courts, and they kind of simulating the French model. And they were all had all transitions to democracy in the 90s, and all the courts had been functioning for 20 years and so. And so we choose the best case, a middle case, and the worst case. And the best case was Benin, Senegal was the middle case, and Madagascar was the very worst case. So, and then we did, I never been to Africa, but my colleagues are experts on Africa, so everyone took the country of expertise, and we did the field work in these countries. I can tell you more about the cases if you want later. But then I would like to tell you something on the courts that these countries have and what they rule for the judges. And we have in Argentina, the ruling constitution establishes 75 years old, but life term is possible because after that age, the judge should be confirmed every 5 years. But this rule has never been implemented, and it was also declared unconstitutional by the judge that is now being questioned because those that made the new constitutions tried to apply it to judges that were already ruling. So the constitutional court, the Supreme Court argued that it should be applied to new judges after the constitutional reform and not to the old one. That's the reason why we have such an old judge in the court still. And then we have Paraguay, where the constitution establishes fixed terms, but the fixed life terms, but the life term has never been used either. So it's quite kind of, and judges rule for 5 years, and they are confirmed every 5 years or not. And this is kind of interesting because you see, we can see from the very beginning that even the constitutional rules are kind of questioned in many of the countries regarding the judicial tenures. And then we have fixed terms in all the other countries, but the length of the terms varies. And Chile has the longest of those terms, 9 years. So with these rules of the game, we expected to find very long judicial tenures in Latin America. But this is not actually what happens. And in Argentina, the average judge should be there for 20 years, and it's not what has happened in reality. So this is what we did. We collected information on all the judges, 148 judges that served in the constitutional or Supreme Courts since the beginning of the democratic periods until now, until September from last year. And we counted 110 judges that left the bench in this period. And with this information, we built a dependent variable. Oh, this is not good. Well, never mind. So we wanted to know from these 110 judges how many, or if any of them, had left because the constitutional rules were being respected, because the fixed terms mandated that they had to live every 5 years or 6 years or whatever, or if they had left because they had been forced to leave the bench. So we had these two alternatives, and we decided that we could classify all these departures in these two ways. Are these due departures or are these undue departures? This was a very difficult process of classifying the departures, because you have to know really the cases very much. You have to know the coyuntura, the coyuntura política very much. What is behind the departure of a judge, and but there are some cases in which you don't have any doubts. If the judge dies, he dies. But we had one case when one judge was assassinated. It was in Senegal. So sometimes they die in a very strange manner. But we had just one case. And then, well, they die, or they reach the 75 years and they go, or they finish with the fixed terms. But sometimes there are, in our sample, there are many judges that resign, for instance. Many resignations. And if you go the normal way, and you analyze, okay, the judge resigns, the judge finishes because of the fixed term, etc., nothing looks suspicious. But if you go in detail and if you look what is behind these resignations, you find very interesting things. So we did this process. We classified first the due departures, which were on which we didn't have any doubt. Then we took all resignations as potentially undue. We didn't know. And then we explored in detail what was behind these resignations. Or these abrogations. This is a very strange word, and it's very difficult to explain. But we have one country, Madagascar, where the terms are abrogated. So no one respects the judicial term. So they are we have actually, well, I'll show you the data later, but it means that they have established in the constitution rules for these terms, but the terms are abrogated. Sometimes the judges stay much longer, sometimes they stay not so long. It depends on the political coyuntura. So we had to include abrogation as potentially undue, and it resulted that most of the cases were undue. Then we did the qualitative assessment, and we had constructed in this way the dependent variable of our study. And this is what we found. So you see the countries, the total of judges serving in the country, the exit of the departures of judges that we judge as due. We don't have doubts that these are due. Then there are those that where we see that the judge was forced out of the court somehow, and then we have a column for those who are still in office. And with these three categories, due, undue, and still in office, we built the dependent variable. And you see the Madagascar has the highest number of undue exits because of this issue of the abrogation of the positions. And we see that all the cases have somehow cases in which you can say there are judges that are not leaving the bench in a due manner. In all countries we found kind of someone who was forced out. But of course there are a lot of variation in the cases. Then this is how the due and undue departures behave per country and across time. And for instance, you see it in the Madagascar and Paraguay, there are peaks of this line, the dotted line, which are the undue exits, and there are crises around the year, and in this year many judges leave. In Paraguay, that was the case of it was called the pulverización de Corte Suprema. The president came and initiated impeachment to everyone, and many judges resigned, and others were impeached until the end. But it was a pulverización because I think one or two only survived the process. And if you go to Argentina, there are peaks around the 94. At the beginning of the 90s, this is Menem. Menem, when he came to power, he packed the court. He enlarged the number of court members, and many judges resigned in protest, and others were appointed. And so there is a change of things there. And also with Kirchner, when Kirchner came to power, he began impeachment to all the judges of the court that had served in the Menem years. So some had to resign, another stayed, and so. And in the other cases, you see where the fixed terms are used. All these peaks show the moment in which the courts are renewed because of the fixed terms. Well, for us, it's interesting. I don't know if for you it's interesting, but for us it was interesting to see more or less that this kind of data in comparison. And then we wanted to explain why some countries have more undue departures than others. And according to the theory that we had all these factors I told you before, the political factors, the institutional factors, the personal factors, etc., we could predict outcomes on this variable. And then our question was, when is the judge going to leave the bench in a due manner? And what makes the probability that the judge is going to leave the bench in an undue manner higher? So we defined different hypotheses and designed all the variables. Should I go in detail there, or what do you think? For instance, I take a couple of those which are for more relevant. The fixed terms is the constitutional rule. So in some countries, we have these 5, 6, or 9 years in which the judge has to serve. And the normative theory predicts that the fixed terms are not so good for independence because they allow the political powers to intervene in the nomination of new judges more often. But we predict in our developing democracies, which are where the rule of the games are not so stable, we would predict that if you have fixed terms, the political powers don't have so much incentive to mix with the courts because they have the opportunity every 5 or 6 or 7 years to change the court in any case. So we wouldn't find so many undue departures in situations in which you have fixed terms because the judges are going to leave in any case regularly in due ways. So we expected to find a negative behavior of the fixed terms in cases in which the fixed terms are so designed in the Constitution. Then we have another important variable, the constitutional reforms. As I told you before, if you have situations in which the constitutions are reformed, this is a window of opportunity for political powers to do something with the courts. So we would expect to find more change of judges in times of or more undue departures also, but also due, because they can do it both in moments of constitutional reform. Then we took the presidential powers, and we expected that the more power the president, more likely that we'll have more undue departures. And then you see the IFI. The IFI is an index that we built in GIGA to measure the formal powers of a court. So it's a kind of, it's very complicated to clarify, but I have the index to show later if you want. But it takes all the definitions regarding the constitutional court or the Supreme Court that are written in the Constitution and builds a measurement. And all these variables include both the power of the courts and the independence. So it's a mathematical calculation of all this. And we expect that when courts are more powerful, the political branches will have more intensive, more interest in mixing with the court. So we expect a positive sign there. And then we have until the moment we're collecting more data, but until the moment we have one political variable, which is called all house. All house is taken from the political institutions database, and it calculates the majority, how big the majority is for the president in Congress, and it codifies. It's a dummy variable in which it's shown if the president has majority in both houses or not. And then we have the three variables where we coded the personal characteristics of the judges. It was a lot of intense work to see if every judge was close to the government or close to the opposition or neutral, and if it had been in some political position before or whatever. And then we have our control variable, which is the natural log of GDP per capita, which is very much correlated with the level of alphabetization and also the level of the quality of the democratic regime, etc. So this is important because we have countries with very different levels of development, and it's very much pointed out in the theory that if you are more developed, you won't experience such a bigger number of undue departures of judges from the bench. So this is more or less what we did. And then we had to run a model. And this is what we did. We chose a survival model, a type of multinomial logic model, which work well with our dependent variable. With this kind of model, we could test the impact of all the independent variables in the different type of departures. So we could test the impact of the independent variables on the due departures and on the undue departures separately. And this was interesting for us to know if there were which were the factors that were impacting more on undue departures or were impacting differently from due departures. So in our model, the baseline category is the judge that is still in office, and we compare. So we estimate the likelihood of both a due and undue departures to this baseline category, the judge in office. So we see for the judge in office, what are the probabilities that he will live in an undue or due way in a particular country. And then we built our unit of analysis. This was also a lot of work. We chose the unit charge quarter as the unit of analysis. All these studies normally do the works annually, but we divided the years in quarters to better test the impact of the political context on the departure of a judge. If you have, for instance, a judge that is going after a new president arrives to power, it's important for us to know that the president was there before and then the judge was changed. So these kind of things you could only do if you subdivide the year in different quarters. So we have many observations. The observations are not annually built, but quarterly built. This is the number. We have more than 1,500 observations for the African countries and more than 2,000 for the Latin American countries. And for 141 judges, we had to remove some judges because Madagascar was not a democracy after 2009. So we couldn't test the impact of the political variables, the composition of Congress, and so on this context of not democratic regime. So we had to leave the last period from Madagascar out. Okay, well, what we found. These are the variables that turn out to be significant. And we found these 4 variables significant and very disappointing for us. None of the personal variables of the personal characteristics of the judge did not play a role. Until now, we have to try more, maybe later. But it was so much work and then they didn't turn out to be significant. But the institutional variables are important. And it's very interesting that the fixed terms are significant. Precisely for the duty partner. So if you are a judge and if you are ruling in a country where the terms are fixed by the constitution, you are probably not going to be harassed so much to lead the court in an undue manner, because the political powers seem to respect more the terms that are fixed than those that are non-fixed. So this kind of interesting, and it's not a finding of our work only, it's also a finding of Perez-Lignan work also for Latin America. So it seems that the rules that regulate the length of the tenure are quite important for how the judge leaves the bench. They didn't turn out with much significance with significance in the undue parties, but they are very significant for the duty parties. Then we have also the constitutional reform, as we expected, with a lot of impact on how the judge leaves the bench, and we see that there is a lot of judge turnover around this time. We define this variable not only taking the months or the quarter in which the constitutional reform was done, but also considering 3 quarters after and before the constitutional reform. So we could see if around the time of the constitutional reform there was also something going on with the displacement of judges or so. And there is a lot going on. We can confirm this. This is also a finding in other works, new works on Latin America. But most of these judges live in a due manner. So it seems that the redesign of the rules of the game allows for a more elegant way of displacing the judges. So most of these judges live in a due manner. Then we have all house. All house is the majorities that the president has. So presidents with a big majority or with strong support in Congress are encouraged, have more interest, or feel more secure to mix with the courts, and they do this in an undue manner. This was interesting for us also to know that it's not so much how powerful the president is in the Constitution, but how powerful the president is politically, which makes him or her to do this, to dismiss judges unduly. And as we expected, the GDP is important, and we are going to have more undue partners in countries that are not so developed, as we also thought. So these are more or less the results we have until now, and then I come to the conclusions, preliminary, and I look forward to the comments also. A preliminary conclusion of our study is that if we didn't find a strong regional divide in terms of due and undue. If I had thought initially that because African politics is more informal, than they don't have so strong political parties and the kind of things we see in Latin America, that they could do more undue, they could have more undue parties than us, but it's not like this. So we have Paraguay and Argentina, and they behave differently from Senegal and Benin, where the terms are more respected. This was for us interesting to know. But still, the development seems to be a very important issue to take into account, and then our work can enter into dialogue with other words, stating that we can't, that in the development democracies we find other behavior of this of the political powers in relation to the judiciary than what we see in established democracy. So we have some evidence for this as well. Then, as I told you, we find out that the fixed terms better protect the judge against undue interferences than life tenures, although the life tenures initially were thought to do this work better, but it seems that they don't. Then we find that judges are particularly at risk in terms of constitutional reform. As I told you, they will live. There will be more judges leaving if the rules of the game are going to change. We also find out, as I told you, that congressional majorities motivate the president to take the political risk of undue interferences with the judiciary. And I think this is mostly what I had to say. I had a lot more to say, but better to wait for the questions.
We still have time. Thank you so much for this presentation.